Yes. First, the bankruptcy code in section 362, which has the discussion of the automatic stay, has some carve-outs. There are some kinds of things that are not stayed. For example, if there is a proceeding against the debtor under the police authority of the government, that typically is not stayed. Certain things associated with divorce or child custody or child support are not stayed. So there are some things that are not stayed, and certain actions by taxing authorities are not stayed. However, the taxing authorities are bound by the automatic stay with a minor exception that is listed. But suppose those exceptions are not part of the program. The creditor is all set to conduct a foreclosure sale, for example, and the debtor files a Chapter 7 bankruptcy petition. And there's no equity in the property. Well, you don't see that these days, but some years ago, there were properties that were way, way underwater. So certainly the second mortgage holder wouldn't be conducting this foreclosure sale, but maybe the first wants to conduct it. And the Chapter 7 bankruptcy is not going to give way to catch up on the mortgage arrearage, because in a Chapter 7, there is no plan of reorganization. So the creditor would like to resurrect that foreclosure proceeding. And the creditor in that situation can file something called a motion for relief from the automatic stay. What the creditor is doing is asking the bankruptcy judge to lift the stay for a limited purpose. This doesn't mean that the stay is non-existent throughout the bankruptcy case. It's for the limited purpose of going after the property. Or let's say the creditor was suing the debtor in the California Superior Court and wants to resurrect that lawsuit. Well, the creditor can file that motion for relief from the automatic stay and ask the judge to lift the stay for the limited purpose of going after the debtor in the California Superior Court. That kind of thing usually doesn't happen unless there's insurance happening, or if the creditor thinks that the debt could be determined to be non-dischargeable under a theory of fraud, then one of the steps in that process would be to resurrect the state court action and continue with the prosecution of that action. So, yes, the creditor can get the stay lifted. The creditor can even get the stay annulled to say that it never was in place in the first place. Now, how could that possibly happen? Well, one thing that was a problem some years ago was an abuse of the bankruptcy process. And this typically involved a married couple. They're facing a foreclosure sale. So before the foreclosure sale happens, husband files a Chapter 13 bankruptcy. Why a Chapter 13? Well, it has a debt repayment plan, and so the creditor is less likely to seek relief from the automatic stay because there is at least the possibility of getting paid through the Chapter 13 plan. But the debtor doesn't file a complete set of bankruptcy papers, files a skeletal, or what's sometimes referred to as a face sheet filing. Triggers the stay, so the foreclosure sale stops. Debtor takes no steps to cure the filing deficiency. So after 45 days, the bankruptcy is dismissed. Creditor restarts the foreclosure process. Wife files. Triggers the automatic stay again. Another face sheet filing. 45 days later, case is dismissed. Foreclosure is about ready to take place. Husband files. And they're tag teaming each other. Well, as you might imagine, the creditors have had just about enough of that. And so they got Congress to change the law. Now what the law says is if the debtor has been in a prior bankruptcy case during the 12 months immediately prior to the filing of the current bankruptcy case, and that prior bankruptcy case was dismissed, of course you would expect that, since why would you file a second bankruptcy case if the first one were still pending? In any event, then the automatic stay is not automatic. Well, technically it is automatic, but it terminates on the 30th day after the filing of the second bankruptcy case, unless the debtor can move the bankruptcy court to reinstate the stay. and the debtor has to show that the two cases were filed not in bad faith. And it has to be done by clear and convincing evidence. So that does create a little bit of a problem for the debtor. If you get past the 30 days, there's no automatic stay. And then if you've had more than one bankruptcy case pending during the 12 months prior to the filing of the current bankruptcy case, there is no automatic stay. Do not pass go. Do not collect $200. So in that situation, just as a prophylactic, the creditor might want to get a comfort order saying, yeah, there is no stay, so I can go ahead and conduct the foreclosure proceeding without any concern about being hailed into the bankruptcy court for violating the automatic stay. In sum, a little bit long-winded, but yes, creditors do have some recourse if there is an automatic stay in place.